Before we start, I should just mention that the court's ordering that no one should publish or reveal the name or address of the child who's the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the child or any member of his family in connection with these proceedings. If anyone's in any doubt as to the effect of this order, copies are available. Now, we know that you've agreed very helpfully on an order of speeches. As you might imagine might happen, having read your very helpful respective cases, we have formed a preliminary view on this, and it seemed to us that the fairest course to take, rather unusually in the circumstances, was to call on Mr. Harrison first.
Certainly, my Lord. My Lords, my Ladies, we respectfully submit that if my learned friends are correct in the submission that they advance to this court, it means that the European regulation has had the effect of empowering the executive to restrict the jurisdiction of the Supreme Court by sending a letter to Brussels. We respectfully submit that this proposition, which they advance, is not supported either by our domestic legislation or by any principle of European law. The domestic law position is governed by the 1972 Act, and in the first authorities bundle at tab 20 appears the Act in its original form. We have included this in the bundle, my Lords, my Lady, because the wording of Section 2, as set out in this version of the Act, was that which was in force at the relevant time, that is to say, at the time the Brussels II revised regulation came into force. The court will see that the power of the executive under the Act is specifically limited by subsection 2 of Section 2, which provides that, subject to Schedule 2, at any time after its passing, Her Majesty may, by order in Council, and any designated ministerial department may, by regulations, make provision, and then the purposes for which provisions may be made are set out in A and B. And so the first point we respectfully advance is that the power of the executive under subsection 2 to legislate is specifically limited to legislation by order in Council or by regulations. And then they have to be for the purposes set out in subsections A and B, which include implementation of community obligations. Schedule 2 of the Act appears on internal page 20 of this document. And by paragraph 1C, the court will see that the executive is impeded under subsection 2 from sub-delegating, in effect, the powers that arise under that subsection. We respectfully submit that under our domestic law, a letter which notifies information to the European Commission is not capable of having legislative effect under the 1972 Act because it falls outside the scope of subsection 2, and for that reason it is not a relevant enactment for the purposes of the Constitutional Reform Act.
So what do you say about subsection 1 of section 2, which is the relevant one?
We respectfully submit that subsection 1 does not, contrary to the submissions made by my learned friend Mr. Mercer, confer any specific power on the executive. The authority which my learned friend relies upon for the proposition that by virtue of subsection 1, subsection 2 can be bypassed is the Eridania case, which appears at tab 35 of, which is in volume 2 of the authorities bundle. The relevant paragraph which he cites, which my learned friend cites in his written case, is paragraph 34 on internal page 2771 of the report. And what that provides is the fact that a regulation is directly applicable does not prevent the provisions of that regulation from empowering a community institution or a member state, and I highlight the words member state, to take implementing measures. In the latter case, the detailed rules for the exercise of that power are governed by the public law of the member state in question. However, the direct applicability of the measure empowering the member state to take the national measures in question will mean that the national courts may ascertain whether such national measures are in accordance with the content of the community regulation. And so we respectfully submit that what that passage makes clear is that the powers arising under community legislation are conferred on the member state. They're not conferred specifically on the executive, and they can only be implemented by the member state in question in accordance with the rules set out in the national law of that member state. And in this case, the relevant rule governing the means by which the executive can exercise its powers to implement legislation, we submit is subsection 2 of section 2 of the 1972 Act. Since receiving Learned Friend's written case, we have dug out a further authority which is not in the bundles, but with the court's permission, I would like briefly to take your lordships and lady to a passage in that. Might I hand copies up, please? This is the Imperial Tobacco case in which Lord Hoffman gave a dissenting judgment, but although his judgment was by way of dissent, what I respectfully submit is that in the passage to which I'm going to refer the court, he eloquently and correctly set out the relevant principle, which in effect is the same principle that was articulated by the Court of Justice in the Eridania case. The relevant passage is on page 862 of the report. Under sub-paragraph 5. Now, what I ought to point out is that in this list of paragraphs, what Lord Hoffman was doing was commenting upon various propositions deriving from the judgment of Lord Justice Ward in the Court of Appeal. And so the first one or two sentences under each one are a direct citation from the Court of Appeal's judgment before Lord Hoffman passes comment. And so one needs to start under subparagraph 5 with the sentence, "This, in my opinion, is also fallacious." What he then said is the directive confers no powers upon the government. All it does is to impose obligations upon the United Kingdom as a member state. The powers of the executive branch of government of the United Kingdom are entirely a matter of domestic law. It is section 2.2 of the Act which confers legislative power on Her Majesty and Council and the Secretary of State. There's no need as a matter of community law for the executive to avail itself of section 2.2 or for section 2.2 to exist. The legislative branch of government could discharge the community obligations of the United Kingdom by enacting primary legislation. So we
But that's about a directive, of course.
Yes, I accept that.
And there's all the difference in the world between a regulation and a directive. And the regulation is self-executing by virtue of subsection 1 of section 2.
Well, my lady, yes, if the regulation has direct effect, which is a point I'm going to come on to. But we say that the relevant provisions of this regulation fall within one of the exceptions to the rule of direct effect.
It all depends, does it, on whether your piece of European legislation, in this case a regulation, is conferring a power on the state or simply stating a rule having received information from the state.
Well, what I was going to come on to that in more detail.
All right.
In a nutshell, what we say is that implicit in the regulation is that the information communicated by the executive organ of the state should be correct. The regulation doesn't expressly cater for the position where what has been communicated doesn't match up with the position as a matter of domestic law.
I mean, following Lord Hughes's point, if the first stage of the process is to be conducted by a district judge, and if the state, in its return to Brussels, simply says, and under our system, a first appeal, of course, is to a High Court judge, and under our system, a second appeal is to the Court of Appeal, is that, as Lord Hughes has importantly asked you, is that really the exercise of a power, or merely the sending of information over as to how we do things here?
We respectfully submit it's the latter, my lord. It is the communication of information.
But I thought you were saying that, I thought you were drawing our attention to where the executive has and has not powers. And if you concede that the notification procedure isn't the exercise of a power, then I don't fully understand the submissions you've been making over the last 5 minutes.
Well, my lord, we say that the notification procedure, however one views it, is incapable of amounting to an enactment because the ability of the executive to legislate is specifically curtailed by section 2.2 of the Act, and that there's no freestanding ability that the executive has by virtue of subsection 2.1, for example, to issue a notification to Brussels, which by a side wind has some form of legislative effect.
I think it was Mr. Turner who, at some stage in his written case, suggested that the regulation was the enactment for the purposes of the Constitutional Reform Act. Speaking for myself, I think it's more helpful to consider the 1972 Act, Section 2, and importantly, as Lady Hale has said, Section 2.1 as the enactment, the relevant enactment, which has to be read with the regulation and with the notification that dots the I and crosses the T.
Well, my lord, we submit that absence any domestic route by which the notification is capable of being an enactment, that is the only possible remaining basis on which it can be asserted that that is the case. And for that to be the case, it is necessary, we say, to demonstrate that the relevant provisions of the regulation have direct effect. Now, we respectfully submit that Articles 34 and 68 of the Brussels regulation need to be read in conjunction with one another. If one looks at those articles, neither one, we suggest, And I mean, and for the court's reference, the regulations in Bundle 1 at tab 9.
Yeah.
Neither article confers any power or indeed any obligation upon member states necessarily to bring about any substantial amendments to their domestic law.
Absolutely not.
What we suggest is that the articles read in combination, first of all, import an implicit requirement upon member states to ensure that their domestic procedural law accords with the aims and objectives of the regulation. Secondly, they have an express requirement in Article 6, express requirement for member states to notify, pursuant to Article 68, the proceedings, and that is the word used in Article 34, by which orders made under Article 33 may be challenged. We respectfully submit that implicit in that obligation is a requirement that the information notified to the Commission should correctly state the position as a matter of domestic law. And so the crunch question in our submission is what happens when the notification contains a misdescription of domestic law?
What happens if there's no notification?
Well, we respectfully submit that's such a hypothetical possibility that one doesn't need to entertain it for this simple reason.
As I read it, this is Mr. Mercer's main point.
Well, my lady, as the court will know, there is a gap between the coming into force of regulations such as this and their date of application, a gap of several months. And what happens in that period, inter alia, is that member states supply the information to the Commission, because Article 68 came into force immediately. That requirement was imposed on member states straight away. And so, as it happens, every single member state has provided a relevant notification. What has happened is that two of the member states, Cyprus and Malta, as part of their notification, have drawn attention to the fact that under their domestic law, there exists no further appeal remedy. It's simply not possible to do that. But
the Council regulation was passed in November 2003. It came into force in August 2004. It may have been envisaged that over that period all member states would notify. Maybe they did, but there's no need to assume they thought there'd be a gap.
My Lord, yes, the date of application was some months after the date in which it came into force.
Yeah. And yeah, it only applied in March 2005. Yeah.
Yes.
Exactly.
And I mean, in the case of the UK...
But 68 applied from August 2004.
Yes.
So there was plenty of time.
And in fact, the UK fulfilled that obligation by supplying their notification in November of 2004. And so the real question then is it the case that an erroneous notification can have the effect of creating law, which is the submission of the other parties? Or is it the case, as we respectfully submit, that the notification only has validity for the purposes of this regulation to the extent that it accurately reflects domestic law?
Well, what's erroneous about the notification? Ever since the 1968 convention and all these other conventions that build up to Brussels II revised, the pattern has been for, as I understand it, a second appeal, and only a second appeal. Well, what is, if that's right, and it may be wrong, but if that's right, what's wrong in saying our second appeal goes to the Court of Appeal?
My Lord, there's nothing wrong with saying that, but the error, we say, is in the failure to highlight the limited ability that litigants in this jurisdiction have to challenge orders made by the Court of Appeal by way of a further appeal to the Supreme Court. And so in order accurately and fully to describe the position as a matter of domestic law, the notification should have said that in much the same way, for example, that the Irish notification has made the position clear as a matter of Irish law in connection with the maintenance regulation.
So what you say is wrong with it is it forgets about Section 40, subsection 2,
Correct.
or the Appellate Jurisdiction Act before that.
My Lord, yes. Now, what... see, as regards all the civil instruments, such as the 1968 Convention or the Brussels I regulation, in each case there was a relevant enactment in this jurisdiction which spelt out the position so far as appeals are concerned. And moreover, in those instruments, the appeals procedures appeared within the body of the instruments themselves. And so they were set out in the 68 Convention under one of the subsections. In the Brussels I regulation, they were set out by way of an annex to that regulation.
Can you just give us the reference to that, one of those? Can you just give us a reference to one of those in the bundle?
Yes, of course. They're all in the first volume. The Brussels Convention is behind the very first tab, and the Brussels I regulation is behind tab 8.
The problem about the very first tab is that, correct me if I'm wrong, this is the original 1968 version, and in the written cases, there have been important references to the alteration in the Brussels Convention when the UK acceded to the EU. And speaking for myself, I was very keen to find the Brussels Convention as amended. But where is it in this bundle?
My Lord is quite right. Regrettably, it doesn't appear in the bundle. I don't quite know how that has happened, and I can only...
Would it be possible, after this hearing, for that to be provided to us?
Yes, of course. Of course. So far as the Brussels I regulation is concerned, that's at tab 8, and the relevant specification of appeals is in Annex 4. And so what one can see is that Annex 4, in effect, contains a cross-reference to Article 44, and the wording of Article 44, we respectfully submit, has some significance in that it spells out that the judgment given on the appeal may be contested only by the appeal. And we submit that the word "the appeal" is an important word in this particular context. It's the same word that appears in the 1968 Convention. By the time one gets to the Brussels II revised regulation, the language used in Article 34, the equivalent article, is notably and significantly different, we submit.
Is it?
Before we go there, how did Brussels I become law in the United Kingdom?
There was a statutory instrument which brought it into, well, a statutory instrument which brought it into effect, but in fact, it had direct effect.
Exactly.
And the annex will have had direct effect.
Exactly.
Because the annex spelt out, without the need for anything further, what the various courts were, which is not the case, we say, with Brussels II revised.
So let's just look at the differences. You've got, as you say, in Article 44 of Brussels I, contested only by the appeal referred to in Annex 4.
Yes.
And is the equivalent in our regulation 34.
Yes.
Only by the proceedings referred to in the list.
Yes.
That's significantly different, is it?
My Lord, we respectfully say it is. It's a change in terminology, and it cannot simply have been accidental. If one looks at the later maintenance regulation, the wording used in that more recent regulation it's in Article 33. It bears a greater similarity to that used in Brussels II revised. Instead of the proceedings, it refers to the procedure.
Is there any reason, sorry,
After you, please.
is there any reason to think that Brussels would have intended a different approach in relation to these different regulations?
Well,
Other than the difference of words, which you could say, I suppose, shows there might have been a different intention, but policy reasons.
policy reasons, and also if one looks at it in its historical context, it was around that time that the European Union was witnessing an enormous expansion.
Exactly.
And having to incorporate a huge increase in the number of member states who were parties to it. They all have their own different legal systems. And so when one thinks back historically to 1968, there were only 6 parties to that original convention. They all had comparatively similar internal procedures. They all had the possibility of having cassation appeals, the equivalent of appeals on a point of law. There was only one contracting party to that regulation, the Belgians, who needed to make any form of amendment to their domestic procedures so as to bring themselves into line. And so it will have seemed a reasonable and proportionate aim to try to harmonise the legal systems of those 6 contracting parties. But by the time this Brussels II revised regulation was coming into effect, the position will have seemed quite different. I mean, particularly when one bears in mind a lot of the new member states were from the Eastern Bloc, which had very different systems internally from some of those which applied in Western Europe.
Well, may some of them have had systems which could not or were not happily described as appeals.
My Lord, yes.
Yes.
And so when one, for example, looks in particular at the equivalent notifications given in relation to the maintenance regulation, which uses almost identical language to that in Brussels II revised, they appear behind tab 13.
Yes.
It's quite clear that that certain other member states certainly didn't interpret the provision of Article 33 as restricting the means of challenge to a single further appeal in the manner that had been intended in the early civil instruments.
Where's Article 33?
Article 33 it appears behind tab 12. One sees it provided the decision given on appeal may be contested only by the procedure as distinct from the proceedings.
And is that another relevant distinction, Mr. Harrison? Or not in this case?
It may be, but we say it's more. It bears a greater similarity to the word the proceedings that appears in Article 34. I mean, if one looks at the subheading to Article 33, that uses the term proceedings, and so it may be that procedure and proceedings are used synonymously.
I know you've moved on to the maintenance regulation, but just coming back to Article 34, your emphasis on the word proceedings, I think Mr. Setright points out in his case that in the French version of Article 34, the word that in English is proceedings is appeal, appel.
Well, my lord, it's not.
It's not.
It's not appel, and that was one of the points I was going to make.
I see.
The word in the French is recours, which literally means recourse. And so that could mean appeal, but it could mean proceedings, or it could mean, as Mr. Seshwright has pointed out in relation to some of the other languages, it could mean methods. In one of the authorities in the bundle, the Germany and the Commission case, there's a very interesting passage which sets out the approach that that's required to be taken in as regards issues of translation. That appears in Bundle 2 at tab 43.
Thank you. Yep.
And starting, if I may, at paragraph 95.
Yep. 4483, yep, yep. Or 4482.
4482, yes.
Yep,
Grateful.
yep, yep.
It says, for the purpose of a literal interpretation,
Yes.
this all appears under the subheading literal interpretations. The judgment sets out the different...
Then it goes through the different things. It's really the paragraph 96, is it?
It's yes.
95 sets out the subtle differences.
95 and 96 read in conjunction. What 95 makes clear is that the different language versions are all equally authentic.
Yes, yes.
And so when one is undertaking an exercise of interpretation, it's important to bear in mind all of the language versions and to take from each of them the different nuances that certain words may encapsulate, and to try to reflect that in an overall judgment. That of course, is only one aspect of the interpretation exercise. As the judgment goes on to make clear, there are other ways by which these regulations fall to be interpreted, including by reference to their historical context and also by reference to their purpose and objectives. So the point I was about to make in relation to Article 33 of the Maintenance Regulation, which uses almost identical wording, is that other member states, or at least certain other member states, have not interpreted that as meaning that they are bound to limit themselves to a single further appeal. The best example of that is Ireland. The notification is behind tab 13, and the Irish entry is on internal page 23.
Thank you. Yes, we've seen that. Thank you. Yep.
And then it's, it's self-explanatory. Appeal on the point of law to the Court of Appeal, and then in brackets, it should be noted, however, that in accordance with the Irish Constitution, the Supreme Court has appellate jurisdiction. And very similar to the position in this jurisdiction, we say.
You say that what should have been notified under Article 68 is what Ireland has notified.
Yes.
Yes.
Under the maintenance regulation.
Yes, we say a notification along those lines would have correctly described the position as a matter of...
Well, what's meant by warranting a direct appeal? That means leaving a single appeal but to the Supreme Court, is it? Or to the Constitutional Court?
Kind of leapfrog appeal.
Leapfrog, it's the equivalent of a leapfrog appeal. So it provides...
So it's consistent with the idea of a single appeal? No.
Well, my lord, that part of it is, but then the final sentence is, we respectfully suggest, consistent with the idea that multiple appeals are possible.
Yeah.
I think there's clearly been some discussion in the past in Europe at the drafting stage about the desirability of not having, as it were, limitless appeals, particularly in questions relating to enforcement or recognition. But is there any reason why only should carry the connotation that there should be a single? Or does it simply mean only as provided by the relevant notification? In other words, in no other way than as provided.
Well, one needs, we submit, to bear in mind that in certain member states there are different procedural avenues of appeal, and so it's possible to pursue what we regard as a conventional appeal that happens in this jurisdiction, but equally in other member states, one can attempt to have a complete rehearing.
Yes, there's an appel and a cassation, certainly. What I'm getting at is whether the word only, I mean, what's your submission? Do you say the word only carries with it the implication that it means one further and no more? No.
Our submission is that its appeals are to be undertaken in accordance with.
By these methods and no other?
Yes.
Yep.
But implicit within that is that the methods notified correctly reflect.
Well, that's the bit that's the hurdle which presents you with a problem, isn't it?
I accept that is a more difficult issue for us, but we say that it must bear that particular meaning.
Right.
When you look at it purposively, I take the point about the ambiguity of only that Lord Hughes has articulated. When you look at it purposively, there is a lot to be said for a conclusion that all these instruments only expect for and allow a second appeal. But even if that's wrong, ever since the UK joined the EU, it has been making these notifications, first of all under the 1968 Convention. Here there will be a single further appeal, namely to the Court of Appeal. So that's the line that's been consistently taken in this jurisdiction for decades.
My Lord, yes, and so far as the early civil instruments were concerned, that did not present any sort of problem, because number one, it was a specific requirement within those instruments by the use of the word the appeal to specify only one. And number two, the instruments themselves incorporated the methods of appeal in their body, either under one of the provisions of the instrument or by an annex which formed a part of the instrument, and which is, as I say, in the case of Brussels I, had direct effect, leaving aside the fact that it was additionally, in a belt and braces fashion, implemented by a statutory instrument. We submit that our proposition that a notification only has validity to the extent that it correctly describes English law is correct, essentially is supported by 2 points. The first of these is that if one reads Articles 34 and 68 in combination, which we suggest, and as we suggest they must be, these articles do not, we submit, have direct effect because they are articles which require member states to adopt measures in order to implement them. And for that reason, our submission is that they fall within an exception to the general rule of direct effect, which we have addressed in our written case at paragraphs 14 to 19, where we have set out fairly extensively some of the authorities where this particular exception is canvassed, most pertinently and most recently in the OBB case about compensating railway passengers. So we therefore say they do not have direct effect. They depend on their efficacy on the measures taken by the member states, and for those measures to have any legal validity, they must be adopted in accordance with the public law rules of the member state, which in this case would mean compliance with Section 2.2 of the 1972 Act. The second proposition that we advance under this subheading is that a rule which meant that information notified to the Commission necessarily had binding legislative effect, however erroneous it might be, could lead to absurd results as a consequence of administrative errors made by officials in government departments. It could also, we respectfully submit, undermine the objectives of the regulation where the notification was manifestly erroneous. This, in our submission, is not merely a hypothetical proposition, as can be demonstrated when one examines Article 29 of the Brussels II regulation. Article 29, it's behind tab 9,
Yeah.
and it's on page L33811.
Yep.
Has two subparagraphs, which in certain cases may be inconsistent with one another. Paragraph 1, this all relates to the initial application and the court to which that initial application ex parte must be made. An application for a declaration of enforceability shall be submitted to the court appearing in the list notified by each member state to the Commission pursuant to Article 68. So on the face of it, in common with Article 34, if lists and if information notified is to be binding, then whatever we say about that would be binding by extension of the same principle. But paragraph 2 of the article says that the local jurisdiction shall be determined by reference to the place of habitual residence of the person against whom enforcement is sought, or by reference to the habitual residence of any child to whom the application relates. And so, prima facie, the plain meaning of paragraph 2, we suggest, and paragraph 2 spells out the jurisdictional position and is therefore directly effective, we say, is that the local jurisdiction falls to be exercised by courts local to where either the respondent or the child lives. So if you have a child who's living in Cornwall, one would have to make the initial application to a local court there, to perhaps a court in Truro. Conversely, a child living near Carlisle, the local application would have to be made to somewhere in that vicinity. Now, support for that specific proposition as regards the internal position is to be found in the authority that appears behind tab 46, Sanders and Verhagen, which was concerned with similar wording in the maintenance regulation.
Yep.
This case was all about Article 3 of the maintenance regulation, which had a very similar rule of local jurisdiction. And the issue in this case was whether it was permissible for the German state to concentrate jurisdiction pursuant to Article 3 in regional specialist courts as opposed to the specific, more local courts in the towns where people lived. And so to translate that, it's the equivalent in this jurisdiction of saying that jurisdiction lay, for example, with the Brighton District Registry as regards somebody living in Eastbourne as opposed to in Eastbourne County Court. So the issue in this case was that permissible? Now, at paragraph 57, the Advocate General described this similar rule, appearing in the maintenance regulation, as one which had direct effect.
Yeah.
And the conclusion of the court, right at the very back of the report, summarised in the ruling in bold,
Yeah.
was that even that regional concentration of jurisdiction might fall foul in certain instances of the requirements of Article 3, unless it had another objective justification, which was a matter for...
Quite a big unless, isn't it?
Well, my lord, yes, but it's a very big unless in the context of the issue that was then before the court.
Yeah.
The issue was regional versus literally the very town. Now, when one looks at what the UK has done in relation to Article 29, one sees... sorry, we have to keep jumping around bundles, but behind tab 10 of bundle 1, on internal page 53
Yep.
of this document,
Yep.
so far as list 1 is concerned, the application is provided for by Articles 21, which deals with divorce, and 29, which is the one which we're considering, shall be submitted to the following courts, and that in England and Wales, the High Court of Justice, principal registry of the family division. Now, we respectfully submit that that notification, which purports to concentrate the entirety of jurisdiction under Article 29 in one court in London, is in plain contravention of the directly effective provisions of Article 29(2). And we submit that Article 29(2) was framed as it was for very good reason, which is that when one is seeking to enforce a foreign order in relation to a child...
You understand?
Yes.
So what?
Well, my lord, so we say it cannot have been intended by those who framed the Brussels regulation that information notified by the member states should be binding in all circumstances. It should rule the day, irrespective of anything else. And so here we have another misdescription, so far as England and Wales is concerned, in relation to Article...
But this is an entirely different point. This is simply saying that the document as submitted doesn't comply with the regulation. Let's assume that's right. So what, in relation to this case?
Well,
I can't quite see where that gets you.
well,
Let's say legislation was required and we don't comply with the directive. Well, so what? In that sense, it doesn't comply, but it doesn't help construe other parts of the legislation.
we respectfully submit, my lord, that it does for this reason,
Yeah.
which is that the proposition advanced by the other parties in this case is that notifications must have binding force, even if they're incorrect. And
Depends what you mean by
Incorrect,
incorrect.
exactly.
I mean, if there's a list, a list is a list. And your notion of is it a correct list is a sort of figment of your side's case, isn't it? Well, you can't get it out of the language, because the language simply tells you to look at the list.
Yeah.
And the list is the list.
If the list doesn't
That's all
comply,
there is to
then
it.
we fail to comply, but that's a different point.
we say that for the list to be valid, it needs to
Be valid.
it needs to reflect the correct position as a matter of domestic law.
Why? And also, why doesn't it?
Well, because in order to bring about a curtailing of the jurisdiction of this court would have required a domestic law enactment.
So the underlying idea of having a single court, which is spread right across this area of EU law, must surely inevitably involve a choice of a particular court's jurisdiction. It's implicit in the whole scheme that there will simply be a list of courts, and that may involve the deprivation of the jurisdiction of another court, which might otherwise have had jurisdiction but for the list.
Well, my lord, we submit there is, in contradistinction to the civil regulations, the language used in the two family regulations does not require member states to confine themselves to one further appeal pursuant to the relevant articles, and to the extent that there is any implicit obligation to amend their national rules of procedure in order to comply with the objectives of the regulation, that can only be achieved by taking measures that are valid under the relevant law of the member states. The change to the law, to the domestic law, is not brought about by the communication of information pursuant to Article 68, and therefore it must be implicit that there should be a match between what is communicated and what has happened. It's a fundamental requirement, we suggest, of community law that in order to be binding, rules and regulations need to be published. Now, it's quite striking that one document that we don't have in any of these bundles, because certainly we have not been able to locate it and Reunite have not been able to locate it, is the UK's notification. What we have instead is the consolidated list of notifications, but that comes with a very big disclaimer on page 1.
Where do we see that?
It's behind tab 10. I mean, the reference in that disclaimer to the possibility of corrections implies an acknowledgement that there may be errors. And
well,
so,
but at the moment, do you accept that on the face of it, on the best evidence rule, we have to accept that this is accurate unless there's reason to doubt it?
well, my lord,
Or where do we go? Or do we just say we don't know what the UK said?
what I submit is that this all supports the proposition that the notification, that there's no particular formality that seemingly required for this notification. It's just member states shall notify, just as Article 67 says member states shall communicate, requires the passing of information to the Commission, which is then published in this sort of form. That passing of information has no special status. It cannot have.
Well, you say it's got no special status, but the argument against it is very simple. Once it's notified, then by virtue of the regulations, once you notify under Article 68, by virtue of Article 34, that's the only place you can contest. That is the effect of the regulation as a matter of ordinary language. Whether the notification is mistaken or fails to comply with the regulation, that is the effect of what it does. That is brought into English law by the 1972 Act. If it doesn't comply with the regulation, then that may be a question of infringement or whatever, but it doesn't alter the fact that that's what's said against you is the effect of what's been done. What's it matter if it's a mistake or not intended?
Well, my lord, I mean, we say it matters a very great deal because the process of notification envisaged under the regulation is a relatively informal one, in contrast to what is required to legislate pursuant to Section 2.2 of the Act.
But that may be true, but Article 34 is clear in what it says, isn't it?
Well, my lord, on its face it's clear, but...
well, that's a good step in the right direction, at least.
But what we say is that it must surely be implied, because that what is to be notified pursuant to Article 68 correctly states the position as a matter of domestic law. Because
So how does it work? Is the notification invalid as a whole? Have
no,
we,
it's only,
have we, you say we failed to comply with the regulation?
we say that it's valid only to the extent that it reflects the position as a matter of domestic law. So the notification in this case, issued pursuant to Article 68, correctly identifies that a matter of English domestic law appeals from the High Court lie to the Court of Appeal. Now, the notification doesn't, for example, say that one requires permission. So if one adopted an entirely literal interpretation of it, one could say, well, one has an appeal as of right to the Court of Appeal, but no one has suggested that that is the case. But where the notification does not have effect, we submit, is in the inclusion of the word single further. Those words are, if one likes, ultra vires, in that there was no, the executive had no basis for communicating that without having taken first the necessary implementing measures pursuant to Section 2.2 to curtail the Supreme Court's jurisdiction.
So really it comes down to whether Article 68 is merely requires information to be given, or whether it requires information which can of itself be determinative of rights.
My Lord, we say that is the case because it's not entirely fanciful to envisage a situation in which
Article 34.
a notification refers to a court which, under domestic law, has ceased to exist for whatever reason, or because amendments to domestic law, as a result of an oversight, have not been communicated. It cannot be the case in that type of situation that, as a result of the notification, the defunct court's jurisdiction should somehow become revived. It may seem like
yes, but the trouble with that is mistakes also get made in legislation. They don't only get made in notifications. The mere fact that mistakes may get made. I see the argument that taking away the jurisdiction which this court might otherwise expect to have through the means of this sort of notification is something you wouldn't certainly expect in domestic law. But this has to be seen in the European context.
Well, in a sense, it's a problem very specific to the more recent regulations. It's not a problem that arose at all in relation to the early regulations, where the position was spelt out and where those regulations were themselves able to have direct effect. And so it's only a problem here because of this notification procedure, which is relatively novel. So, we ultimately submit that the two. I realise I'm straying over my time.
No, well, don't worry. That's not a general indication you've got.
No. I didn't take it as such, my lord. That the two articles, 34 and 68,
Yep.
Need to be construed purposively in accordance with the overall objectives of the regulation, and by reference to general community principles such as effectiveness and proportionality. Now, on that basis, the preservation of a limited jurisdiction in the highest appellate court to determine issues of fundamental public importance that will affect children throughout the jurisdiction and affect the way in which proceedings relating to children throughout the jurisdiction are conducted, does not in any way infringe the overall purposes of this regulation. Indeed, we submit it enhances them.
Do you say this point is act clear in your favour?
I appreciate the difficulty in advancing that proposition, given the compelling arguments the other way. But what we do submit is that there is a basis on which this court might find that it is surely act clair that those who framed the regulation cannot have intended that domestic law should be altered by virtue of an administrative mistake, which is what we say the submissions made by the other parties amount to. An administrative error on the part of the executive creates a dramatic alteration.
So you say this was an administrative error, do you?
Well,
You say it's an administrative error because you say Article 68 is to be read as merely requiring the administration, the executive, to give information as to the legal position.
yes.
And do no more than that, not to refashion the legal rights or reduce them.
Oh, yes, there's no specific power.
That's a simple point. isn't
Yes.
it?
And so...
It's merely a notification procedure, you say. It isn't a power of substantive law.
Yes.
Or changing the law.
And
changing the legal position as it would otherwise be.
my lord, yes. And therefore, the administrative error is in communicating something that differs from the domestic law position.
It's information, to use the second paragraph of
Yes.
68, not
And
not a decision.
And because if it is right that erroneous
Yes.
information can have the effect of changing the law, then if an official having an off day wrote into the commission and said, well, you know, that these appeals will lie to the magistrates' court, well, following the argument through, that would be binding. It's, theoretically, I accept unlikely, but it cannot. But equally, it cannot have been the intention behind the regulation that sort of miscommunication should have binding effect and be incapable of being interpreted by domestic courts in a manner whereby that was in effect ultra vires and therefore disregarded. Because of the absurdity the absurdities that would create. And to repeat, we do submit that the lack of binding effect of these notifications is supported in our submission by the language of Article 29 and the conflict between those two paragraphs. On the one hand,
yes.
Paragraph 2, which does have direct effect, and Paragraph 1, which merely cross-refers to the notification procedure and carries with it an expectation that notification procedure will accurately be complied with. So, to conclude, we invite this court to accept that the notification provided by the UK should be read as if the words "single further" did not form a part of it, because the executive had no ability to include those words as part of the notification in a manner which had legislative effect under our domestic law, and it should also be read as retaining the inherent ability under our domestic law to emphasise very limited circumstances which will not have any material impact on the effective operation of this regulation, to pursue appeal to the Supreme Court, and thus allow this court to proceed to determine the appeal as regards which it's already held, and the permission should be granted on the basis, presumably, that an issue of public importance.
That's not a problem, absolutely, yeah.
And so, for those reasons, we respectfully say that this court can proceed to hear the appeal. But in the alternative, we say the matter is not at clair.
Understand. Thank you very much.
Unless there are any further matters, I can assist the court with those myself.
Very clear and helpful. Thank you very much indeed, Mr. Harrison. Mr. Germain.
Nothing further to add, my lord. Thank you.
it leaves people in a slight state of uncertainty, but I think the fairest way to deal with this is to say we'll let you know where we are at 2 o'clock. We'll resume again at 2. Thank you very much. Court's now adjourned.